Hello, how are you? Good to see everybody here. It is Saturday, and we are going to do a little live stream here. It'll be about be about an hour, I would expect. And as usual, I will put all of the substantive stuff up on the front end, and then of course at the end I'll tell you about some up and coming stuff, and the grift and all that stuff. So because I know that some people just want to get to the meat of what I'm advertising, and that is the right of petition today. And this is one of those shower revelations, I will say. And if you've read my book, Prepare, you'll know that I keep little yellow stickies and little things like pieces of paper around, and I'll have a revelation. I actually have a pad in my bathroom that is a waterproof pad that I can write ideas. And I don't know why I didn't think of this before, but I have previously done a cert petition to the U.S. Supreme Court on the right of petition. Now, you understand this is part of the First Amendment. We're going to go through it kind of in depth and look at this in a way because it doesn't get talked about very much, and I think it's relevant to some stuff. The reason it kind of hit me was because it's relevant to some stuff that's going on in our culture right now, in our society right now, and I think that it's worth talking about a little bit more. I haven't heard anybody else talking about it, and I try to give you some unique insights. So before we do that, let's say hello to who's in our chat. And of course, I've been chatting with none of your damn business over in Rumble. So thank you for being here. And you've got Jacob Peets and Snorkelbop. Hello. Thank you for showing up and hearing what we have to say. And Brit Brat, Sadie, Just Joy, and let's see, Danielle, of course. Hello, Danielle. I just got back from Orlando, so Wim and Jean, Pat, and let's see, Rage Star, and of course everybody who's watching on the replay, which isn't now, but will be later. All right, so what are we talking about when we're talking about the right of petition? What is that? Well, that is off of the First Amendment of the United States Constitution. So Bill of Rights, First Amendment. And most people, there's a lot of stuff in the First Amendment. People know about freedom of religion, freedom of the press, freedom of speech. But let me read the relevant portions of Amendment 1. Congress shall make no law abridging the right of the people to peacefully assemble and to petition the government for a redress of grievances. There is surprisingly little litigation involving the right of petition. Usually people talk about free speech, and they usually think of things through that lens of free speech. There's all kinds of litigation on speech. Very little on the right of petition. Now, there is some, but not a lot. So let me read this once more because it's very important to understand the text. Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. All right, now here's the first mistake. People have a very constrained view of what a petition is. A petition, here's what people think a petition is. I'm going to go around and gather petitions and have people sign things on my petition and submit it to the government to demand that the Congress act. All right. That's what people think a petition is, right? Because the word is used, petition, is the same as a petition, as in I petition the school board to get rid of this book, or I petition the prosecutor's office to get those dirty videos out of the video store. That's old school. But I suggest to you that petition as used in the First Amendment is much, much broader than that. Much broader than that. Let's talk about a couple other amendments that are relevant to this, and that's the Fifth Amendment, which says no person shall be deprived of life, liberty, or property without due process of law. And also the 14th Amendment, which says, nor shall any state deprive any person of life, liberty, or property without due process of law. So there's two due process clauses in the Constitution. One's contained within the Fifth, and one is contained within the 14th. Okay. So with that, I want to talk about another concept that you need to understand. Let's think about it from a free speech context. And there's a lot of free speech is sort of one of the deep dive. It's a very complex area of litigation and law. Now, people say, I'm a free speech absolutist. Well, what does that mean exactly? It's actually not a very sophisticated view. Now, I am not a First Amendment lawyer by any means, at least when it comes to the right of free speech. In many regards, I'm a criminal lawyer, so when people try to criminalize speech or criminalize the right of petition, now we're getting to the nub of the matter, then I will be fully engaged. I would say the hardest class I had in law school was Professor Murchison at Washington and Lee Law School. Great professor, brilliant. He is a legend at Washington and Lee and a very good First Amendment lawyer. And he is the man. So and it was so hard. His class was so hard. But let's just talk about the First Amendment and absolutism versus maybe the way that the courts actually view speech. All right. And let's just think about that. Now, you may disagree politically, but I will suggest to you that all rights have some limitations on them. All right. So what is it? Well, first of all, at the bottom of the least protected speech under the First Amendment would what we would call criminal speech. Now you say criminal speech. What in blazes is criminal speech? I'm glad you asked. Criminal speech might include something like my agreement with a mob hitman to kill my ex-wife. Now, all I did was engage in speech. All I did was talk with him and conspire with him and agree with him using words and speech in order to solicit a crime being committed. So I am being criminal. I am being charged and being put away into prison for words that I spoke. So criminal speech is not protected by the First Amendment. Now, how can we expand the circle a little bit? Can you think of other examples where speech might be criminalized? All right, think about it. But generally, I would say the go-to example that I would use is conspiracies in furtherance of a crime, usually murder. Antitrust can be criminal. So conspiring with others in order to price fix, okay, which is all basically conspiring and talking with others, communicating with others. Extortion could exist. For example, I go to a bank and I fill out a little piece of paper and say, give me all your money. Well, all I'm doing is just free speaking, right? I don't even have a weapon. I'm just giving the bank teller a note. So I'm exercising my speech. If I verbalize it or I write it, that's speech, isn't it? How can you criminalize that? Extortion. I will do X, Y, and Z if it's a threat. Assault. I'm going to hit you. I'm going to shoot you. I don't shoot you, but I'm threatening you. That's speech. You see, but that's criminal speech. So not protected by the First Amendment. Fair enough? All right, let's move a step a little bit more protection. There's something called obscene speech. Obscene speech is minimally protected by the First Amendment. So we talk about, now some is absolutely not, like child pornography, but what about just pornography generally? Well, the courts view pornography as of lesser, if it appeals to the prurient interest and has no educational value. Back in the day, I did some law school stuff on this, but basically stuff that is just, pictures of dead bodies, speaking obscenities, using the N-word, all these things are basically not valuable speech. It's of low value in the speech continuum. Now, it doesn't mean that it can be criminalized, but it also means that it has the least protection amongst the speeches that you can make. Now let's move it up another tick. Okay, so we're going here, we're moving up to more protected speech. The next one that is more protected, that there is some protection for, would be commercial speech. So, for example, advertising. Morgan or Morgan, Porta people. Okay. Now that's advertising. He's promoting himself. There are regulations from the Florida bar, which is we have an integrated bar in Florida, and those regulations regulate what can be said to promote lawyering. And so therefore you have regulations on truth in advertising. There is some regulation that applies to commercial speech. So it's more protected than obscenity. So we're moving up. And in fact, it does have some value. You need to have a marketplace of ideas, but it is not the most protective form of speech. What is the most protective form of speech? The most protective form of speech is political speech. Now, why is that? The most protective form is political speech because that is the grist of democracy. That is the way we communicate our political opinions and disagree. We hash out. We seek truth through the marketplace of ideas. So this is the ideal of free speech that we all adhere to in a free society, is that speaking politics and discussing openly our politics and not being able to criminalize or penalize or regulate political speech, that is the highest form of speech and is the hardest for the government at all to regulate. As well it should be, because it's the most valuable form of speech. It serves the political process for us to make correct decisions and to right the ship of state when it gets off track. Okay? So we get this continuum of speech from least protected to most protected. So just think about it. Think about speech in that way. Now, I'm just saying that this is the way that it is. Okay. And Pat, we're not going to get direct. We're going to talk generally, and I'm going to talk conceptually, Pat. So you're on the right track, but let's stick with it. Okay. Criminal speech, obscene speech, commercial speech, political speech, with political speech being the most important. All right. Fair enough? Great. Okay. So now let's shift to the right of petition of the government. Now, what does that mean? It doesn't just mean writing out a little piece of paper. What that means is that I can speak to the government for a redress of my grievances. I can go to the government and complain. I can speak to the government, and that speech to the government, even if it falls under one of these other things, is protected because it is a citizen speaking to the government or petitioning the government for a redress of grievances, complaining to the government about something. So you don't just have a free speech implication, you have a petition implication. When I fill out a petition for a redress of my grievances, that is protected separately from the fact of its speech. All right. So you got that concept? So it's a fine line, but I'm gonna tell you about. I've got a great example. I'll tell you the facts of the case that I took to the U.S. Supreme Court and got denied. That we'll talk about that. I want to talk first just generally about the right of petition. All right. So here is. Let me give you a little bit of case law, just some blurbs from case law. All right. The right of petition confers absolute immunity on efforts to influence government policy in a non-corrupt way. I'm going to read that one more time. The right to petition confers absolute immunity on efforts to influence government policy in a non-corrupt way. Any of you lawyers out there? I know we got a couple. I think I saw MG Law. MG Law in the chat. MG Law, can you tell me what the name of this doctrine is? It comes from a case called Eastern Railroad President's Conference versus Knorr Motor Freight. Thank you. And it's called the Knorr-Pennington Doctrine. Also a case called United Mine Workers of America versus Pennington. That's 1961 and 65 U.S. Supreme Court case called the Knorr-Pennington Doctrine. Really want to read this one more time because it's very important, class. Get your pencils out. Okay. There might be a test on this later. The right of petition confers absolute immunity on efforts to influence government policy in a non-corrupt way. Okay. The right of petition is separate and distinct in that it applies only to petitions to the government, but confers absolute immunity on the content of those petitions when done for the purposes of redressing grievances. Okay, hear that? So if I have a complaint, let's say I think there might be election fraud, and I go to the government and write something or say something to the government because I have a concern that my election was corrupted. The right of petition, that is a petition to the government for a redress of grievances, and it is absolutely protected under the right of petition. Okay, let's keep going here. As law and technology have developed, the need for citizen checks on police behavior has increased in importance. All right, so this is I'm gonna skip ahead. This is from a brief that I did, and I think that it's very consequential to what we're dealing with right now. Without the ability, okay, I've got, I don't want to get into my case just yet. I'm going to see if I can skip ahead here, and I'll tell you about my case. So turning a citizen complaint into a weapon against the complaining citizen cannot be consistent with the right of petition. Right? So if somebody complains to the government in a petition, anything's a petition, a speech to the state for a redress of my grievance, to criminalize that and to create a weapon against the speaker is absolutely what the right of petition is there to protect against. Criminal sanctions brought by a state public official against citizen who question their official conduct cannot be tolerated. Now, what I'm doing is I've actually had I had this case, and let's get into the case a little bit. And I want to preface it, and I'll tell you more about the facts of the case and how this might work out in the real world. But these quotes that I'm taking is right out of my cert petition to the U.S. Supreme Court on this issue. Now, I will say, here's my first complaint or point that I want to make to everybody here who's listening. I'm a public defender. My clients are poor. They're in the bottom 10% generally of our society, and they get overlooked. And a lot of people don't have much sympathy for my clients. And they say, well, he's guilty anyway. Who cares? Right? We get a lot of that. Well, this isn't important. That doesn't affect me because I'm not a criminal. I'm just Joe Blow. And they wouldn't do that to me. So, and that attitude pervades the elitists that sit in our courts and sit in DC and sit as judges and sit on appellate courts and everywhere else. Don't you fall to the trap to that, because you are my good students, right? Protecting the rights of the individual at the bottom is what is a protection against us. It's a protection against us. The Bill of Rights protects all of us, individuals, by enforcing the law and enforcing the rights and using the protections of the Bill of Rights to protect the lowest among us. We are protecting ourselves from the same weaponry. Now, I will suggest to you that in my experience, we have failed in this attempt. Our elites have failed because they've used these divisions. Well, that's just the poor people. That's just the criminals. And so they get away with demonizing a segment of the population and dividing us. So my public defender client gets no rightful hearing in the courts. Now, when the same issue is impacting on somebody that somebody cares about, the game has already been rigged. The law has already been made. Thank you, Unilinks. Unix super sticker. Hey, that's a cool super sticker. I don't know if I've had a super sticker before. That might be one of my first super stickers. So it's one of the clears. So yes, please do hit the like and subscribe and donate lots of money. I would say if I sold $100 or if we had $100 donations and books and stuff, I'll drink and show you my surfing scar. But anyways, but that hasn't been achieved yet. That's probably going to another. All right, so let's move back to write a petition. Now I'm going to give you the facts of my case. I've got had a client who, let's say, decided to record a police officer during his duty. And because he feels that he is not being treated properly by the police. So he records and audio records a phone call with this police officer, takes the phone recording, burns it on a disk, and submits it to the police department, the sheriff's department, the Volusia County Sheriff's Department, to complain about this officer, and says, and see attached audio recording of your officer behaving badly towards me. Got it? He's feeling like we don't need to get into too much of the facts. Let's just say that he feels that he's being abused by the police. He's not being listened to. So he records himself, burns it onto a disc, and submits it to the Volusia County Sheriff's Office complaining about this deputy. What does the Sheriff's Department do? Well, they conduct an investigation, which is what they should do, right? A citizen complaint, they need to check. They found it was unfounded. Fair enough. Then what the police department did is turned around and charged him with a felony for recording the police officer without his knowledge or consent, because we have a two-party consent rule. Hey, Valhalla, good to see you. Okay, so we have it. So my client's petition to the government for a redress of his grievances was turned around into a felony against him on the very recording that he attached to the petition for his redress of his grievances. Got it? So in this context, I challenged and so this was the Florida's interception of oral communication statute is either this case, I challenged it. I actually tried the case. I had motion practice in the trial level. I was the lead attorney in the trial. And I will tell you that I won at the trial level. I reduced it was actually 3 felonies, and I reduced it, and I won, and I got a 1 second-degree misdemeanor. So that's a big win for my client. But I will tell you, I was not satisfied because I felt that my client should have been immune from prosecution for his petition to redress of grievances. So I took it to the district court, and when they affirmed it without opinion, didn't even write an opinion on it, I petitioned the U.S. Supreme Court to review my client's conviction because his right of petition was turned into a weapon against him. All right. So my first statement. So what I did is I said this is overbroad and he's protected constitutionally. But then I also said Florida statutes, which is 934.03 for you taking notes at home. Florida statutes defining interception of oral communication is overly broad as applied under the First Amendment and the Due Process Clause, because the statute criminalizes legal, constitutionally protected conduct and provides insufficient safeguards and constitutional protection regarding the right of petition. See why this came to mind, by the way? Are you following along at home? Do we understand where this affects us? So we can't complain to the government anymore without being turned into criminals. So let me get a little more detail here. And actually, over on my locals channel, I have posted the entire petition. So if you want to see what a U.S. Supreme Court cert petition looks like, I've got the document posted over on my locals channel so that you can look at it. I took it and I edited out a lot of the facts and the stuff just so we can talk law. But I think you need the context to understand what was going on. My client's complaining about a sheriff's deputy. He submits a document to that. They turn that document around, attach that, and say that's a criminal action based on the document itself that he submitted. Now, it may have been illegal if they had obtained that in some other way. If they searched his computer or they found out later, whatever, that may have been a criminal act. But to take the petition itself and turn that into the basis for the complaint is unconstitutional. In fact, I actually nailed down it was a fun trial, I must say. I rocked that trial. It was a big victory. That was a big win for our client. But our client was just a lowly little taxi driver. And here we got all this prosecution machinery. We had the judge and the prosecutors and the jury. We had a full jury trial. And I remember I asked the cop on the stand, I said, so tell me, have you ever done this before? No. Never charged anybody before in this way. And then I said, is this a petition for a redress of his grievances? The cop on the stand said, yes. And then I also said, is the basis for this charge the very document that he submitted to you? The answer, yes. So I had it really well framed. But he's just a poor taxi driver. Who cares about him? So let's talk a little bit about this. Okay, now let's just think about this as far as the recording, because now I'm going to get a little more case specific about the two-way recording statute, right? So the two-way recording statute is at issue in the case that I had. So this applies to that more specifically. It may not apply to the political ramifications we're doing, but the concepts still apply. There's a case called Wren, W-H-R-E-N, Wren versus United States, 1996 U.S. Supreme Court case. And I remember I had a racial profiling case where a guy was clearly being racial profiled. I knew the cops, and the guy was a black guy. He was driving while black, and I knew this cop, and I knew this cop was a dirty kind of cop because I'd previously been a prosecutor and had to deal with him. I knew what his game was. And the circumstances, everything about it, it was a racial profile stop. All right, just let's assume that. You may not agree that that happens, but let's assume that it happened once in my case. And I remember I had this case, and I was doing the appeal, and I said, man, I'm gonna make all this arguments about racial profiling, and I'm gonna talk about all this stuff, right? And I remember the appellate. I was a brand new appellate attorney at the time, freshly minted, and the appellate attorney says, well, what are you gonna do about Wren? I said, what am I gonna do about Wren? Says, let me get back to you on that, because I'm like, I don't know what Wren is. So I'm like, R-E-N-N. I'm looking it up for Wren. What the hell is Wren? So I did all the best I could. I couldn't figure it out. So I finally went back. What was that? You said Wren. What was that? It's W-H-R-E-N. Wren. Oh, okay, Wren. So then I went back and looked it up. And here's what Wren says. Wren is a case where the cops had an objective reason for the stop. Let's say the guy blew a stop sign and was speeding. All right. But he's black. And let's say the cop even says, I stopped him. Not only, well, I stopped him but I have a reason to stop him. Let's say they're a KKK member, the cop is, all right? But the guy really did blow the stop sign and was speeding. What Wren says is that the courts cannot get beyond, if there is an objective reason for the stop, they can't get into the subjective motivations of the cop. Now, we understand this makes a lot of sense because most people are sick of like, oh, cops always getting attacked. If every police stop becomes an inquiry into racial motivation, the whole system breaks down, right? So any traffic offense committed by a driver provides a legitimate legal basis for a stop. Now, what is the implication of Wren? Wren case makes officer observations the critical question in any police-citizen encounter. So now I've got a case, and let's say my client says, hey, I didn't blow the stop sign. I stopped at it. In fact, I saw the cop, and I made sure I stopped. Looked around, and I pulled forward, and I was going the same speed, right? And then the cop says, oh, no, I'm swearing under oath that he ran the stop sign and was speeding. All right, now we've got it. It's the cop's word against your client, who's scumbag, criminal, lowlife, and we don't care about him, right? And we got the cop. He's got the badge and the uniform and the gun, and he looks really professional, and he knows, and he's going to obey the law. So he'd never lie, would he? So how do we deal with that? So what happens is judges are extremely deferential to cops. And if you get this he said, she said type situation, the cop wins 99% of the time. Now, I don't know that is the right, I don't know. That's tough, because that means the cops can really make something up and stop you for any reason. And bad cops know this, and they will make up reasons that are lies so that they can stop you. And there's a lot of little wiggles like this. But what Wren does is gives extreme judicial deference to police officer testimony, and it results in citizen defenselessness against officer testimony. And given the fact that a law enforcement officer holds the power to charge an individual with a crime and send someone to prison based on his word alone, the average citizen needs access to some defense against the words of a police officer. Is that fair? So in a two-party consent state, can we allow a cop who is on duty using a police phone, sitting in his police offices in his police uniform, to assert that he didn't consent to being recorded by a citizen? Question. Without the ability to record a rogue officer and report this behavior to the supervising authorities, without fear of retaliation, the average citizen is defenseless against law enforcement deference by the prosecutors and the courts. And the Constitution means what it says. The Bill of Rights was written as a shield to the people from such prosecution-happy state overreach. I stand by that. That's my statement. I stand by that. All right. So let's talk a little bit more about this two-party consent statute. Florida statutes, you can look it up right down at home. 934.034A, Florida statutes, makes it a felony to intentionally intercept, endeavor to intercept, or procure any other person to intercept or endeavor to intercept. So that's the first thing. 2, any wire, oral, or electronic communication. 3, of another person. Intercept defined as oral or acquisition of the contents, whatever, blah, 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 blah. Okay. Then there's some other stuff here. Consent, listen to this one. In Florida, consent of the recorded party is only a defense if it was given prior to the recording. Prior to the recording. So that means if the person does not know, is recorded, they say, I didn't know and didn't consent, but then later gives consent, that is not a defense. How do you like them apples? Now, whether that has jury appeal is a different question. But the fact is the prosecutor will ask the witness, well, did you consent at the time? No. Did you know about it? No, I didn't know about it, and I didn't consent. But I have now that I'm on the stand here, I don't mind and I consent. Jury can still convict you of a felony. Really? Okay. And this might come in later, and we're going to go through some examples of why this is overbroad, all right? There's no lack of knowledge on the subject. So that means that even if the subject is aware of the taping and chooses to speak anyways, the crime may still occur. So if the person is being recorded and they know they're being recorded, and then later on they say, well, I didn't consent to that. That's not a defense. So you have to get explicit permission to record. And this is audio, not video. It's audio. Okay. So let's go through some examples. So this is how screwy this statute is and why it is a obscenity. Upon the horizons here. Good to see you, Harpon. And Jacob Peets. Good to see you. All right. The statute criminalizes scientific studies with a hidden camera component. The statute criminalizes nanny cams installed in homes for the protection of infants that record sound. How about that? Did you know that? The statute criminalizes nursing home monitoring for the protection of the aged. The statute criminalizes daycare monitoring for the protection of children. The statute criminalizes actions of the blind who might seek to record their immediate environment for later study or review. Got it? And Jung Min Shelley, I would not take a bench trial. I had a jury trial on this one because the judge did not grant my motion to dismiss based on constitutional protection. Let's go through some more things. The statute criminalizes candid camera or cash cab type entertainment in Florida. So think about it. I didn't know that I was being recorded in the cash cab, and I didn't consent to it, but I won the money. Now I consent to it, but I didn't consent at the time. That criminalizes the cash cab thing. See there? I know that appeals to people who want to make money. They want to get the cash cab. Not in Florida. The statute criminalizes audio note-taking in business meetings. The statute criminalizes audio note-taking in a school environment. The statute criminalizes recording someone who is asleep and snoring, which I don't really snore. My wife does. I've recorded her without her consent while she's asleep. So I committed this felony, but not for pecuniary gain. The statute criminalizes journalistic investigative reporting. For example, undercover video for voter fraud detection or 60 Minutes types journalism. Does this ring a bell? I'm not mad at you. I love you. Thank you for showing up. Okay. As in the statute criminalizes citizen monitoring of police activity, even in public. Now, there may be a little exception for that. There's a Massachusetts case, and there's some litigation. It's a federal law on this. But they convicted my client of a misdemeanor because I won at the jury trial. They wanted to nail him with a felony, but the jury came back with one misdemeanor out of 3 felonies. So they convicted him of a misdemeanor crime for recording the audio recording of a cop who he felt was abusing him and submitting that to the police officer to complain about that cop. Does that sound overbroad to you? Does to me. The statute effectively disarms citizens from legally documenting their interactions with rogue police officers, along with criminalizing a large swath of innocent conduct. Okay. Class? Okay, let's see. The statute is unconstitutional because it criminalizes the exercise of an enumerated constitutional right, and that is the right to petition the government for a redress of his grievances. And then here's a case out of New Hampshire from 1980 that I like. It says, when a statute threatens a fundamental right, special judicial scrutiny is required, and laws which by their broad language leave the police unfettered discretion in enforcement are invalid, particularly when their potential for use in the suppression of First Amendment rights is great. Does this ring any bells with you just to what's going on right now? Retaliatory government action against the right of petition. Somebody is petitioning the government for a redress of their grievances, and the state is criminalizing that behavior. They're criminalizing that speech. They're criminalizing that writing. They're criminalizing that communication. Okay, we've talked enough. Let's look back at the chat here. Yes, upon the horizons. That was a big jury trial win. Yes, 3 felonies to a misdemeanor. Yes, and I'm very happy with that result. I would have liked to have had my petition. I would have liked to have my district court have reviewed and thrown out that misdemeanor conviction because it violated his constitutional right to petition. I would have liked the trial judge to have granted my motion to dismiss based on constitutional protection because he was petitioning the government for a right to redress his grievances. But that was denied. The appellate court affirmed that conviction without discussion. The U.S. Supreme Court turned down my cert petition without discussion. Now, but my guy's just a taxi driver. Who cares about him? Okay, so Toodly, let's answer some questions here, and feel free to super chat or rumble rant, or super sticker or buy a book. All right, some questions. So I can understand some of this in regards to a person's privacy and confidentiality being affected, and what the video would be used for. Well, not all. Many. First of all, the statute as it's written is overly broad and vague. So that's number one. My first response. My second is that when it is wrapped up, when its recording is wrapped up in a petition for redress of grievances, special protection is cloaked in it. They can't use that petition, that document, as a petition, as a weapon to weaponize against the citizen. So there's that variation. And also, there are many states that only have a one-party consent state. Okay, so let's see. Let me go back. Looks like there's a lot of chats here. And let's see. Well, I don't know. I think we're good. Not many chatters here. My chat is going on those. All right, so that's our right of petition. So do we get a point? Do we see some analogies here? Do we see some criminalization of politics? Some criminalization of people who have complaints against the government, who are being turned into criminals by our government for the very fact of their complaining? I think this is something that needs to be very much addressed in any kind of appeal, any kind of motion practice of anybody who is facing this kind of criminal sanction. The right of petition needs not to be forgotten. The problem is there's not a lot of right of petition cases on the books. I was hoping that would help my case get to the U.S. Supreme Court, or at least somebody write on it, because the right of petition is separate and distinct from the free speech right. It is a separate thing, and that means absolute immunity is conferred upon documents that are submitted to the government for redress of grievances. So, yeah, it's not the quality. It's not the quantity. It's the quality of the chat. Fair enough. Good enough, Porcelain Thunder. Okay. Let's talk a little bit. I had a death. Let's talk about some stuff coming up. So anybody we're done with the petition stuff, unless somebody super chats or rumble rants, I've said my piece on that. That's pretty important to me. And if anybody has contacts with anybody, make sure that the appellate and the lawyers who are dealing with these criminal cases are looking at the right of petition. That's my urgent call. I will say that I just got back from a death penalty conference over at Disney. Everybody laughs. Death penalty conference at Disney. And I have the hook on a very good interview who will be coming on my Rumble channel and my YouTube channel to do a nice long live interview. And his name is Herman Lindsay. You can look him up. He was on Florida's death row for 3 years and was exonerated. So he is an actual living human being who was tried, convicted, and sentenced to death in Florida, and based on circumstantial evidence. And the Florida Supreme Court, back when they had a strong circumstantial evidence rule, which they have backed away from, said that his conviction was based purely on circumstantial evidence, and he therefore should be immediately released. So he was on death row and was released off of death row. Very rare, but I want you to hear about him. I want you to hear from him and hear his story. It was based basically on a snitch who was in prison with him, or was in jail with him at one point, and or in a holding cell of some sort. And the snitch, who was a suspect in the murder, said, "Hey, this guy, he confessed to me." And then the snitch was used to leverage it so that 12 years after the murder, he was arrested and tried and convicted and sentenced to death. He was on death row for 3 years. You can look him up, Henry Lindsay. So I'm hopefully going to have an interview. Bring your chats. He's agreed to do an interview. He was at our conference. Jenny L.J., thank you very much for the super sticker. That is great. So we got about 15 more minutes. I wanted to tell you also, just those guys that are hanging with me for a long last few minutes here, 15 more minutes. I also, at our conference, of course, we have, this was a death penalty conference. So we had some of the attorneys who represented Nicholas Cruz in the Parkland shooting case. And they were very interesting. But what was even more interesting is we had 2 of the 3 jurors who voted for life in the Parkland shooting case. And they spoke. We had about an hour and a half discussion with them to understand their thinking, understand the process and how it impacted them. And we got to talk to them afterwards in a social setting. And I will say that I understand this is a very controversial thing, especially in Florida, especially for people whose families have been affected by that. But these jurors were very impressive people. I was not quite expecting that, I would say. I didn't know what to expect, actually. And when it was a surprise, because obviously media publicity and stuff like that. But these jurors, they were very thoughtful, very well educated, took their jobs as jurors extremely seriously, and made a very hard decision that I hope that none of us ever have to face, making that decision. It's a hard decision for a juror. Believe me, it was not a whimsical anti-death penalty vote. These jurors were very careful, and ultimately, I believe it came down to brain damage from fetal alcohol syndrome. This kid was clearly brain damaged, and that was not his fault. His youth and his brain damage combined to say that we don't execute the brain damaged people. Now, if you want to debate this death penalty issue with me, I would highly encourage you to get Death Penalty Debates, because this is a balanced view of the death penalty from somebody who's on the inside, who gives you both sides of the issue. And if you want to look at that, please do read this book. And I want your criticisms. Of the book, I want you to say, like, oh, Ghazi, you aren't considering this, or you're not considering this. Okay. If you please do. I want to make this book strong, so that, in fact, I even gave a copy to the fellow that I'm going to have interviewed hopefully soon, who was on death row for 3 years. And he will give you some insights into what it's like to be on death row. And inside there. Where else are you going to get this kind of? Actually, I've given his name because I met him, and I saw this guy speak about a year or 2 ago at one of our other death penalty conferences, and he is great. Really an interesting speaker, a powerful speaker. And ever since then, I didn't have his name, and I forgot his name. And I remember just being enthralled by his speech to us, because a lot of it is, it's bucking up us public defenders who get no's, and doors slammed in our faces, and people laugh at us. And, and it's, motivation can be hard, but he was just saying, thank you for staying dedicated to our causes. And it was very enthusiastic and very, very good. So I wanted to talk with him. And when I saw him at this one, I'm like, I got to have you on my Rumble channel, right? And share him. Now, I've since also said I'm going to share him with whomever wants to get his message out, because it's a powerful message. Okay, so we've got Slidey Pie over here. Hi, Slidey Pie. Just tuned in. You got to go back. We all the meat and potatoes was early. We only got about 10 more minutes here. You got the death penalty book. Good. Haven't started it yet. Okay. Currently reading Summer Friend. So far, so good. Yes, this is a Summer Friend. That's out. This is a misty-eyed view. Look at that. Isn't that pretty? I love books. I'm a lawyer. What can I say? A children's book, Missy Nichols. You're saying, when does a children's book come out? This children's book, it's targeting. It's all available for pre-order right now. So you can go to stevegosney.com and pre-order it. It will be released in I'm targeting Thanksgiving. I'm praying for Thanksgiving. Barring no mishaps, I know my timelines. I know how to make a book. I know how to produce it. So I think we're going to get it out by Thanksgiving. So that'll give it, so that way you can buy it for your Christmas presents, to your grandkids, to anybody. That's definitely a children's book. Summer Friend is really for anybody. So thank you, Slidey Pie. Yeah, does it have a picture? No, it does not. Nobody's ever seen my surfing scar. But no, but we're not going to get there tonight. There's not enough. Unless somebody comes through with a huge donation, it's not happening. We've only got 9 more minutes. So let's see. What else do we got? So yeah, so that's upcoming. You can go over to Locals. My Locals is free. I don't really even know how Locals works. So what I do is I post what's upcoming there, and then occasionally I'll put documents there and things like that you can look up. And I put the full brief, the cert petition, on there about the oral communication cert petition that I read some excerpts of. You can get the full fact panoply if you really want to see what a U.S. Supreme Court cert petition looks like. I've done about 5 of them. And I will also tell you, don't tell anybody, okay, between you and me. No, I can't tell you. I can't tell you. There's another cert petition in the wings. Age range of the book. Brucey is really up through, I'd say, 2nd grade, maybe 3rd grade. First, it's early readers. It's very early readers. Not even that. It's very young, but it does have a Christian message in it. And that's something I want. It's not a hit you over the head Christian message. It's weaved into the story, because I believe life is all about Christianity is infused in your life as you live. You see it when you have it. You see it all around you, right? So your actions may seem mundane, but yet they transcend. There's also a spiritual level. So I kind of wanted to do that with Brucey, which is he's a dog and he's just got one eye. And he doesn't feel like, who would love a dog with one eye? And yet he had something to give the world, and he's loved. It's a serenity. My wife's making tea, so I'm going to be out of here in 8 minutes. So it has a lot of the Serenity Prayer is based a lot on Job, and there's that. There's also how you have purpose in life. It's a pro-life kind of book, in that, let's just throw the dog away, right? He's only got one eye. He's imperfect, but we're all imperfect. So it's not a hit you over the head Serenity Prayer thing. It's a very subtle, beautiful book about Brucey the One-Eyed Wonder Dog. Did I show you? I'll show you this one more thing, okay? I'll show you some of the pictures that I'm really happy with Brucey, how he's coming along. I've showed some of these other pictures. This one's pretty good. And maybe this one, and maybe this one. Okay, so take a look here. Present, share screen, a window. Okay, so here's the here's the first picture. Can you see that? So this is the latest pictures. A lot of these are coming soon. So that's Brucey in the cage. These are set. We're getting through these. Here's another one. Let me see. Present. These are the latest. Now they haven't been colorized yet. This is great one, because one thing that's fun about this is that when the artist did these dogs, I said, can you make them Cocker Spaniels? Because Brucey's nemesis was the Cocker Spaniel. He was a Shih Tzu, and so she did. And then here's another picture. That's when the family comes and adopts him. Now this artist is excellent. I don't know if did I show you some of the. I'll show you one of the color pictures here. Yeah, this is how good this is so good. Here's Brucey. This is when it's a finalized picture. You see that? Isn't that cute? I love Brucey. And it's not all sad, but you have to go through things. I was having a really good discussion with a friend of mine, Brian. I went to Colorado, and I spoke about that last time. Brian it's a long story, but we were having this discussion about blessings. And blessings are not easy. it doesn't mean life is easy. It means life is difficult. That some of those things that are worth commitment and worth effort, it's not easy. It doesn't mean faith doesn't mean your life is sweet and pure and without trauma. Maybe the opposite of that. This here, I don't know about that. Zachariah Anderson, I did not follow that case, and that was a long trial. I'm understand, and I've added some input. I've even communicated with the Anderson family some insights and some tips and some connections that I thought would be helpful. But I didn't watch that trial, so I really feel uncomfortable because it is my wheelhouse, which is criminal appeals, right? But for me to really go out and comment on it whole hog, I mean, I just don't know enough about the case to be, it's a complex case. I understand that everybody that watched it feels that he's not guilty and that it's a wrongful conviction. And what I've seen was a lot of prosecutorial misbehavior. So all of that's true, but I just can't, it's hard for me to really dive in because I'll be talking and I don't know what I'm talking about. I know what I'm talking about when it comes to criminal law, but you also have to know the facts and know when not to talk. So who is the artist? I go to this place called 99 Designs, and I found her on 99 Designs. I work real hard to get an artist that has sort of an artistic, good eyes. So many people are computer drawers. This person is artistic, it looks like a painting. It looks like an old school kind of children's book, which is what I want. Okay, so yes, so Brucey the One-Eyed Wonder Dog, we've got 3 more minutes. Anything else here in the Lord of the Ree? Don't worry, you're always loved. Thank you for being here. And Upon the Horizon, let's give Upon the Horizon some love. We all have difficulties in life, and sometimes that's why you pray in a group, because we're weak alone as individuals. Sometimes we need each other, and all the time we really need each other. And we pray because together as a group in a church, because together alone we will fall against the devil and evil. Let's see. I don't know about some of these things. Okay, well, I think we're pretty good. Any others could use some prayers? Lord of the Ree, let's pray for Lord of the Ree and Upon the Horizon. Very stressful. Yeah, changing living situations at the last minute. Okay, and then Dale's giving me music suggestions. Oh, and Jenny, thank you for the late super sticker. Jen, that's the second super sticker. You've done 2 super stickers tonight. Thank you, Jenny. So I need Vision of Atlantis. I'll look at that, Atlantis. And I'm going to put you all into Chrissy Mayer's stream. So when you get put over there, make sure you tell them it's a Ghazni raid. I think that's so cool. I think that's fun when you guys do that. It's like you get put over in somebody else's stream, like Ghazni raid. I think that's fun. So thank you for doing that. And I don't know about the notifications and how it works, but so go over to Locals, just check out Locals. There is a subscription tier list, but you can subscribe, and I don't think it costs any money to subscribe to my Locals channel. And I do try to just post on there documents and background, things that I'm doing and what's upcoming. All right. So a slidey pie. Why am I reading sidecar on that? That's not good, is it? Okay. Well, I think we've had a good night. And yes, please do go to stevegosney.com. I'm going to be posting. Oh, and the other one or more thing I want to tell you, I'm going to be doing some promotions with Andrew Branca on our American law courses. So I'm going to be teaching criminal procedure coming up in the first week in September. So if you do want to sign up, go through stevegosney.com. There's a link stream. And if you sign up through there, then it helps me out. So we have a deal with that. All right. Well, good night.